Hi, I'm Donald Pitt, the founder and Managing Director of Quality Building Management. As you can see from this list, I hold a large number of licenses and qualifications to be able to discuss this topic with you today. I hold trade qualifications carpentry, joinery and plastering, and I've been a licensed builder since 1981. I've licensing to conduct and certify fire equipment, am a safety professional, fire safety advisor and a licensed asbestos assessor. The topic we're going to discuss today is safety for residential bodies corporate in Queensland. So what's the legislation? Well, we've got the WHS Act and regulations and the Body Corporate and Community Management Act 97. So are bodies corporate responsible for safety on common property? So the answer is definitely yes. And I'll cover the acts here. Is that in the Health and Safety Act, the Body Corporate and Community Management Act, and then there's legal considerations and the duty of care provisions that need to be considered. So the WHS states that residential units are exempt from the WHS Act. So is this true? Well, yes, it is, but read the following from the legislator. So we're talking about here the duties of community title body corporate. So it says here, the common areas are for residential purposes only, and if they are residential purposes only, they are not considered to be a PCBU. So the WHS Act does apply here at residential premises when a contractor is engaged to carry out work there. This is directly from the legislator. Now, I'm going to reference New South Wales work cover here because New South Wales and Queensland have exactly the same legislation. Court cases, they mix and marry and they use preferences from one case to another. So New South Wales does apply here. So this is a direct reference here. They say also that bodies corporate are not covered by the health and safety laws when they're purely residential, unless they directly employ a worker. So exactly the same as Queensland, and they're not a PCBU, and the common areas are considered not a workplace when it's residential only. But read this. This exemption does not affect other duties under other laws, including negligence and strata laws. So do the provisions that they apply to owners, corporations or the residents? Refer back to Queensland. Does it refer to bodies corporate? So it says, if a contractor undertakes common work on the common area, the part of the common area where the contractor is working becomes a workplace for that contractor. Now, in these circumstances, residents are considered others at the workplace. So read section 29 of the WHS Act. So these other persons must take reasonable care for their own and others' health and safety. Therefore, if they're aware of safety issues, and I'm talking about the body corporate here, that may affect the safety of that contractor, they must inform the contractor. So do strata managers now have responsibilities to strata schemes? So here's a direct reference again, where a strata manager is part of their business or undertaking because they're the PCBU. They look after the common area. They take on the responsibilities under section 19 and 20 of the WHS Act. So what are the duties? So you can read this yourself, but it says here that they engage or ensure that others are not put at risk from work being carried out. So when they send a contractor to the site, or when a body corporate manager goes for meetings on the site, the PCBU, which is the body corporate managing company, must ensure the safety of their workers and contractors on common property. So how can strata managers ensure that contractors work safely? And here's a full list here. But in red, advise the contractor of any known risk at the workplace. That is a responsibility. So what happens if an injury does occur on a common property? The body corporate is always responsible. The body corporate is always sued, and the body corporate generally pays. And I'll talk about a couple of cases here. This is a Moroccan decision on the Gold Coast, and it talks about that body corporate owes a duty of care to each lot owner and other users of the common property. Another case, New South Wales, this one is Wu versus Carter. A lady suffered injury due to a defective railing. She was paid $775,000 in damages, and the body corporate paid 75% of those damages. You can see the landlord's agent actually paid 25%. So what are the body corporate responsible for? Making sure that all common property is in good order, make sure that all common property is safe, and body corporate is responsible for the safety of all lot owners and visitors to the common property. And in those cases I'm talking about, those two legal cases, they didn't even refer to the WHS Act, only common law duty of care provisions. So does the body corporate need to engage a professional to inspect the common property? The answer is no. The committee can do it themselves, but then they take on all legal responsibilities. They're liable. So should the body corporate engage a professional to conduct a safety audit? Definitely yes, because then that professional company takes on all legal responsibilities, not the body corporate. So how often should you conduct a safety audit? At least yearly, because things change. I'm Donald Pitt, and thank you for your time today.